So you're kind of talking double-edged here. On one hand, the B&B was so busy you couldn't come to probation, but on the other hand, it wasn't making enough money to pay $1 on your case. Isn't that what you're
That's not
saying?
what I, no, that's not what I was saying at all. The days that it was booked, I never know when it's going to be booked. So I could make an appointment for probation, and then all of a sudden that morning of probation, I get a notice that I'm being booked. I have no idea. So I can go 3 weeks and have no booking, and then that morning I get one, and then my daughter has to come get me, and I go to Wichita and I spend the weekend or however long that it's being booked. And then I have to make an arrangement and meet him in El Dorado versus Eureka, which he was nice enough to do because it was closer. But no, the Airbnb wasn't always booked. It was just, and that was one of my text messages that I didn't plan it. It almost always seemed to happen, either the car breakdown or the place be booked right at the day he gave me to be there, which I informed him always before those appointments. I wasn't making an incredible amount of income. Now I'm enrolled back in real estate school. I'm trying to get my life back together so I can go back to work, get my license back in order, and everything I'm supposed to be doing with my vehicle so I can drive again. I want to get to a situation where I'm either in Wichita full time or whatever. So if I need to, I can use the bus or use my daughter's, ride to get where I need to go so that I can start making money on a regular basis instead of being out in the middle of nowhere where there's not any taxis or buses or jobs. I didn't want to rent out my house. I did it because I had bills to pay.
All right, but once you got paid for the B&B, you didn't pay down on your case, did you?
No, ma'am. I paid the electric and the water and everything to keep the bills on so I could rent it out again and pay the next month's bills.
Did you ever think about getting a job that you went to every day?
Yes, ma'am. Like I said, there was 147 people in Fall River. The grocery store was not hiring. I'm not supposed to be driving. So there's no bus, there's no taxi, there's nothing.
So probation probably wasn't a good fit for you in the first place, then, if you couldn't comply in Fall River.
I
All
mean, I
right.
did everything I could.
Well, I'm not finding the defendant credible when she says she did everything she could and just couldn't pay her case, because I do find, we're not gonna keep negotiating this. I'm making my decision. You need to just stop and listen now. All right. I find that she did not make payment a priority. She didn't take accountability for it. I understand everybody needs to pay their bills to live,
Me too.
but but she didn't, when she did, she kept the B&B busy enough she couldn't keep her appointments, but she couldn't take a few dollars and at least show that she was making an effort. She paid nothing, zero, until May of this year when Mr. Bauer filed this motion. She said she came up with $200 of her own. And then today she came with $166.68 that she borrowed from her daughter. Now, she told him before she was going to do that, but she didn't. The failure to report. If she called in when she was going to miss, she knew she didn't have to have a UA. It was the appointments where she had to come in that anytime she came in was a chance of risking a UA. And those were the ones she just happened to have all the car trouble for. And those were the ones that she was in the wrong town. Mr. Bauer did everything he could to accommodate her schedule. This was a Butler County case, but he didn't make a report in El Dorado, neither did the court. If you live in Greenwood County, you can report in Greenwood County. Oh, you're stuck in Wichita? Well, you can report in Butler County, El Dorado. That's just across the line. She had numerous times from this report that no matter what he did to help her keep her commitments, she just didn't do them. She kept coming up with a reason. Oh, you're in Wichita? Come on over here and to the Wichita facility and have your UA done. Well, when she gets in front of the camera, we will begin. Thank you. Good morning, Miss Cowan.
Good morning. How are you?
I'm good. All right, we are on the record now in the 13th Judicial District, Butler County Case 2024 TR 2429, State of Kansas versus Christy Irene Cowan. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Christy Cowan. Ms. Cowan does appear personally from Courthouse Security 2 video station.
And we also have CSO2 Tony Bauer as a probation officer and potential witness, I presume, as this does come on for hearing on a warrant to show cause why the defendant's probation should not be revoked. We are set for an evidentiary hearing. Mr. Patterson.
Thank you, Judge. Judge, I just want court to know I've taken time to meet with my client. We went through several documents you provided me and discussed those, and we spent a substantial time talking about this case. I can tell the court that following our discussions about the different facts in the case, she is going to waive hearing. She is going to stipulate that she has violated conditions of her probation, and those would be the ones set out in the warrant to show cause.
Thank you. Ms. Cowan, do you understand you do have a right to challenge or deny these allegations of probation violation?
Yes,
And do you understand that you can do that by having an evidentiary hearing wherein Mr. Bauer and perhaps others would have to testify?
yes, ma'am.
And that you'd have the right to cross-examine those witnesses as well as call your own?
Yes, ma'am.
Knowing that, you wish to waive your right to such a hearing?
Yes, ma'am.
And rather than deny the violations, you wish to stipulate, that is, agree that you did violate as alleged in the request for revocation?
Yes, ma'am.
Specifically, your probation officer, Mr. Bauer, alleges that you failed to pay your court costs, fines, attorney's fees as ordered, that you haven't made any payments as of the date he filed this, May 15th of 26. You're acknowledging and agreeing that that is true?
Everything is paid as of today.
But are you agreeing that when he filed
Oh,
this,
yes, sorry.
you hadn't made any payments?
Correct.
And he alleges that as of the date he filed this, May 15th, of 2026, you had failed to report to your probation officer once in June, August, September, November of 25, and then once again of each of these dates, 1/9, 5/5, and 5/14, all in 26, those last three.
Yes,
Okay. He also alleges that you failed to complete a special condition of probation, which ordered you to refrain from drug and alcohol use. He alleges that on June 2nd, 2025, all right, I was looking to see, I thought there was something else checked, but he's alleging that you did admit to using some type of alcohol and that you had dirty tests for alcohol. Do you agree that's what his evidence would show, or what his testimony would be?
yes,
Then there's some talk about employment. You are employed through an Airbnb, is that right?
correct.
Do you own the Airbnb and run it for yourself, or do you work for someone else who does?
Own it.
Okay. And then you do additional house cleaning besides run your own Airbnb?
Yes, ma'am.
And Mr. Bauer's report said that you said you didn't have any money to pay because of your financial situation, but there were times you had to move your probation meetings because your Airbnb was booked, and you were having to deal with that?
Yes, ma'am.
Okay. And that you reported by text on December 4th, 2025, that you had the probation paid in full? Did you text that?
Sorry, no. When?
Okay. He said that you reported by text December 4th, 2025, that probation was paid in full. However, no payments were actually made.
I don't recall that.
Okay, so you can't stipulate to that. You're not saying it didn't happen, you just don't recall it?
Correct.
Okay. Now you filed an indigent request for the court to remove your costs on the case. But you didn't get the paperwork filed in April when you said you would. But apparently that was filed May 13th, and we're going to address that at this hearing. Are you still pursuing that motion, or do I need to ask your counsel that? Mr. Patterson?
That motion is being withdrawn.
Okay. And you told your probation officer at one time you could, I think it was May also of this year, that you're going to go to Colorado to help a friend who is going to pay for the trip. You did that,
Yes, ma'am.
and you were going to somehow through that trip or some other means borrow money from your daughter to pay off the case.
Correct.
But you didn't do that either, right?
I did do that.
You
The
did
case is
borrow-
paid off.
Okay, so you borrowed money from your daughter and paid off the case today?
Correct.
Okay. And it sounds like you've reported you had vehicle issues to keep you from coming to your appointments. Did you report that to your probation officer?
Correct.
Now, he says you did go back and forth between Fall River and Wichita and said you couldn't keep a meeting. So he made arrangements for you to get a drug test or alcohol test in Wichita. Do you remember that incident?
I do not.
In June of 2025, just last year, been a year ago. But you said your ride didn't show up. You don't remember that?
I do not.
You remember saying August 5th to 25, you had vehicle issues and you couldn't make it?
I know that I had vehicle issues, yes, and I've texted him those.
And there were quite a few of those between September 4th of 25 and May 14th of 26.
Correct.
And did you have a conversation with him that meetings are set a month in advance and almost every month you needed to move your date? You agree with that?
Not until the end of my probation.
I'm sorry, I don't understand what you mean.
We didn't have that conversation until the end of my probation.
Oh.
Anything that needed to be rescheduled, I texted him in advance and got his permission to reschedule in advance.
Okay. Did you do that more times than not when you're on probation?
I would probably say yes.
And you admitted to him that you used alcohol August 12th of 25?
I admitted that I had had a few non-alcoholic drinks the night before, yes.
Non-alcoholic. So if he says you admitted to alcohol use August 12th, you would deny that?
Well, he said there was still alcohol in a non-alcoholic drink, so that's where the stipulation came from.
So you're saying you used alcohol, but you didn't know that it was alcohol?
Correct. I drank non-alcoholic drinks at dinner. That's what I
Yes.
ordered.
Okay, that does not sound like a stipulation. So far, everything does. He said you tested positive for UA for alcohol and THC October 14th of 2025. Do you agree with that?
Yes. I admitted to having a gummy.
You said, and you made a point evidently that you bought that legally in Kansas?
Correct.
says January 6th of this year, 2026. You messaged him the day before your meeting because you were in Wichita and you weren't going to make it back to Greenwood County for a meeting. Do you remember that, or do you acknowledge that, stipulate to it?
I believe I was in Kansas City when my car overheated. If we're speaking about the same thing.
I think he mentioned that other. Now, let's make this clear for the record. You're on a Butler County probation, but Mr. Bauer is for the district, and you live in Greenwood County, so he was meeting you in Greenwood County, is that correct?
For the
At
most
least
part, yes.
For the most part, okay. And on this particular date, January 6th, he says you told him you're in Wichita and weren't going to make it back
Oh.
to Greenwood County.
I'm
And
sorry,
so
yes.
Okay, so then he told you to go to Kelly Compliance to set up doing a UA there on that date, January 6th. But then on January 6th, you reported that you were in Fall River back in Greenwood County and could not make it to Wichita to do the UA. And that you
I
had no
don't
way to
recall
make it
this.
to the, okay,
Yeah,
so
I don't
that's,
recall this conversation.
okay. Now, you mentioned Kansas City, and I did see something in here about Kansas City that you were in Kansas City and couldn't make an appointment because your car was overheating
I believe that was
Mr.
in May.
in May. Mr. Bauer, where did I see that in here? I know I saw it. Which paragraph? Fall River. Here it is.
Your Honor, I
got it.
believe that was in the May, that
Mhm,
was the May appointment that she was in Kansas City,
okay.
right
Okay,
before
yeah.
the warrant was issued.
All right, so she was stuck in Fall River, so you moved one of her appointments to January. And then March 2nd of 26, she asked you to move it to March 3rd, or from March 3rd. No, she called on March 3rd and asked to move it to March 6th. May 5th, apparently you did. Then May 5th, she was broke down and stuck in Kansas City and asked to move the meeting to May 14th. Is this the same meeting that kept getting postponed all these months, Mr. Bauer?
No, each month the meetings were getting moved basically any in-person meeting was getting moved. Every
Okay.
single time there was an in-person, it was getting moved.
Okay. All right. And do you agree with that or stipulate for that, Ms. Callan?
Yes.
All right. So it sounds like the only thing that she's taking issue with may be an admission to alcohol use August 12th of 2025. Apparently there was some discussion whether it was like a near beer or something like that. Mr.
And Your Honor, I
Patterson?
don't know. I don't know if this will help her. The August 12th, she admitted to drinking a glass of wine with supper. And
Okay.
then the other one was when she admitted to NA. She denied alcohol use and then
Okay.
said that she had drank some
Okay.
NA beer. And I explained to her NA beer can have minimal amounts of alcohol.
Okay.
Is that what I'm recalling from the old days was they called it a near beer? It was some beer, but it didn't have a very strong potency to it.
It's labeled as non-alcoholic, Judge, but back probably 20 years ago or 10 years ago, I tried to buy it on a Sunday and they said, no, you couldn't buy it. It has alcohol in it. So it says non-alcoholic, it still has alcohol.
Okay, all right. And that's what turns out Miss Cowan, that's what you had?
Yes.
Okay. And you did have wine on one occasion
Yes.
with dinner? Okay. All right. Well, is anyone making you give up your hearing and making you enter these stipulations today?
No.
You understand that if I find that that these statements are in violation of probation, I can revoke your probation and make you serve the remainder of your sentence?
Yes, ma'am.
And that would be regardless of any agreements you've made with the attorneys or the probation officer, that it's the court that must decide. Do you understand that?
Yes, ma'am.
Very well. I find the defendant has knowingly and voluntarily waived her right to hearing and stipulated to the probation violations. I do find she is in violation of probation. And counsel, I understand that there is some agreed upon recommendation perhaps, or at least recommendation. So Mr. McGee, state usually goes first.
Yes, Your Honor. In this matter, somewhat remarkably, if the court is prepared to take judicial notice of its own records, this is a case where it would appear that previously quite sizable lump sum was submitted towards the balance of this case in the amount of $1,158 as of this morning. Following that, pursuant to plea negotiations, the state is prepared to recommend a 14-day sanction. The state's position is that while the defendant is entitled to credit for time served in these types of situations, the state is not recommending that the defendant be granted any jail time credit towards the 14-day sanction per se. Upon the completion of such sanction, if the court does order it, the state would be recommending that this case should close.
You heard her say that her daughter paid that. She could say, well, I borrowed it, I'll pay her back, or she could just say it's a gift. I don't know, but she didn't actually pay that. You understand that, Mr. Bauer? Does that make a difference if you do?
Again, Your Honor, the 14-day section was what was addressed during the context of plea negotiations. I have no personal knowledge as to where this funding might have come from. Merely that the state does consider it quite remarkable given the amount of the payment made as of this morning. But I don't think I have anything further beyond that.
It was my understanding she hadn't paid a dime until today, and I understood she got that money from her daughter when I inquired. But okay,
I
Mr.
did pay
Powell,
200 of my own prior to
you paid 100 of your own. Okay, thank you.
200.
200. All right, thank you. Mr. Patterson.
Thank you, Judge. Judge, we would ask the court to adopt the recommendations, and I want to kind of go into a few things to explain to the court why we think this is an appropriate recommendation. Judge, first of all, dealing with the money issue, again, my client has talked about I talked to her probation officer about her financial hardships, that she would tell the court she's always had trouble with trying to find extra money that's beyond what just living day to day allows her. Had broken cars all the time and things like that. So she was struggling, but the case is paid off now. The state of Kansas is made whole. Butler County is made whole. Where the money came from, I'm not so certain is that relevant, Judge, except if it was stolen from a bank, maybe we might want to know about it. But private arrangements she's made to pay the case off, I think, is between her and whoever she made that with. But it does show that she was made efforts to find the money to get it paid off. So it is paid off. It wasn't paid off during the probation time. She stipulates to that, but it is now paid off so that the case is clear. There were other special conditions that she had, Your Honor. She was to do a DUI victim panel. That and what I note is none of these are on the warrant to show cause, these other special conditions. I do note that I've reviewed text messages that were between her and her probation officer, and that was one of the text message attachments, the DUI victim panel certificate. There's also not a violation. There's a requirement that she abide by whatever recommendations of a drug and alcohol evaluation. Again, no alleged violation of that. So there were specific conditions that are directed towards the DUI that she's completed in this case, Judge. In addressing the times that are listed as missing, Judge, what I would note, and of course, Your Honor, you've been doing this for decades, I have too. I think there are egregious misses that I would term as no call, no shows, where the probation officer sitting there waiting, and somebody doesn't call, they don't show up, and then maybe a day or two later, they'll get back and say, oh, I'm sorry about that. That's really egregious to not even try and get with the probation officer, where she has called and rescheduled at least and kept in communication. Again, I reviewed a lot of text messages between the two of them. They had a good dialogue, by text message all the way through this, so she wasn't disappearing. But she talked about problems with the meeting, asking for permission, getting permission to reschedule, and obtain that permission. But it's understood that doing that many times causes frustration to the probation office, causes them to cancel meetings, leave time open. So my client understands that that was not appropriate of her. Taking a gummy from a local place in Wichita. Again, I've heard the court tell people before, it's still not something I allow you to do while you're on probation. I'm not sure my client had heard that, but I think she understands that it tests positive for THC, can't do that. She admitted to having a glass of wine. Overall, Judge, I would ask the court to consider that it was not a complete failure of a probation, and that it's understood a sanction is in order. We'd ask the court to consider the 14-day sanction given what she has done and accomplished, but also she has some failures in the case, is paid off now. So we'd ask the court to consider the 14-day sanction and close the case. Thank you.
Thank you. Okay, one of the things I've been doing here is calling up the defendant's record in Odyssey. And I'm looking at SG 2026. LM 10858, City of Wichita Public Works and Utilities versus Christy Cowan. Looks like they took a judgment July 4th of this year.
May I speak, Your Honor?
Christy.
No. No. And then I see our GW 25 CR 8. Driving under the influence, that was January 23rd, 25, and along with that, possession of firearms while under the influence of alcohol and drugs, ignition interlock violation, no insurance, driving while suspended, transporting an open container and one-way glass or sunscreen. Those were disposed of March 23rd of 26 by dismissal, it looks like. Mr. Aguirre, is that right? Those charges were all dismissed? Filed January 27th and dismissed March 23rd of the same year, filed in 25 and dismissed in 26.
Your Honor, while I cannot speak to the specifics as to any cases occurring in other jurisdictions, if the court is prepared to take judicial notice of its own records, that case does appear to reflect a March 23rd, 2026 dismissal.
Mr. Bauer, did you deal with that? Were you aware of those charges and dismissal, if that's what that was?
I apologize, Your Honor. What case was that?
Judge,
Greenwood 2025 CR8. I hear what you're saying about, what I think you're going to say, Mr. Patterson. I'll let you go ahead and say it though.
That if these were charges, they were from prior to the time she was on probation, so they would have no effect on this probation.
Okay, but they might towards disposition, and she has a BU 2024,
And they
You
were
dis-
dismissed. Oh, sorry, Judge. Apologize.
and they were dismissed. Yes, and I would agree with that.
Your Honor, was you saying
Yes, sir.
Greenwood
Yes,
CR8?
yeah, Greenwood. Yeah.
That is a case
25,
that
25
was
CR.
suppressed.
Okay, suppression is granted. Okay, thank you. All right, but then she has a BU 2024 ignition interlock and violation of restrictions. Disposition, guilty plea to DUI. Looks like the other was dismissed, but she had a DUI. That's probably one of these two cases. We have the 23, BU 23, driving while suspended. Now, this 23 case, I've looked at it up close because when she was convicted and sentenced, she had two cases. And as plea agreement, Ms. Cowan, the BU 2023 TR 2854 was dismissed for plea agreement. That involved driving while suspended second or subsequent and operating with expired registration or tag. And then when you when we addressed the 24 TR 2429 that we're on the show cause for, those charges included ignition interlock violation, driving on restrictions, and there was a DUI charge in that, and the DUI was dismissed. No, I struck that in a DUI, and you pled to the DUI. So you pled to the DUI, and you had the other charges dismissed in that case, the 24 that we're on today. And you had a second case dismissed in its entirety. So one could say, arguably, that you had a break getting the conviction you got, and then you got a break getting put on probation, which is not unusual for a DUI. But you've got a long history in various counties going way back to a lot of these are civil judgments, but you do have like there's a fitness center and a motor company, things like that. And while those aren't criminal charges to tell me whether or not you're likely to be a success on probation, in some ways they do, because if you have a long history of not making good on what you promised to do, it makes me wonder if I should trust you to promise to obey and abide by your probation. And then you do have a lot of traffic violations, habitual violator, guilty plea in exchange for dismissal to registration in 2011, and a lot of those kind of things going through here. So it looks like you have had a lot of opportunities over the years on probation.
Judge, may I comment on that?
Go ahead.
Judge, what I tried to look through pretty quickly as the court was going through those also, and what I didn't find in my quick review was any prior warrant to show cause in those cases.
Well, I didn't see those, but I didn't call the cases up individually either.
And that's
So-
I was pulling each one individually, Judge, trying to find that, and I didn't find that.
So your position is that even though she's had a lot of probations, they've been successful.
It appears from the record that I've seen, yes.
But see, on the other hand, I would say if she keeps getting probations, that's not success. That means that she's not learning from that probation. She still violates the law. In fact, if anything, maybe she's learning that it's not as bad as all of that. She doesn't have to do any jail time. She'll just get put on probation and add it to the next probation. And so she'll perpetually, don't roll your eyes at me, please, ma'am.
No,
Maybe it's just, she'll just perpetually be on probation, and what's another charge? It'll just roll over with it. Mr. Bauer or whoever can just keep supervising her, and she'll never have any significant consequences to make her change her behavior of driving without insurance, driving without registration, driving under the influence, transporting open containers. It looks like she's just made a lifelong habit of violating traffic laws, putting the public safety in jeopardy every time she does. And it doesn't look like there's anything making her think she needs to stop doing that. Here we are still, all these years later, still going through this DUI. The ignition interlock device that the count two that was dismissed suggests she had that on there for a reason. Violation of restrictions on her license was dismissed. Those restrictions were on there for a reason. Now, she did get her alcohol and drug evaluation for sentencing, it looks like. Everyone agree with that?
Yes, Sean.
Okay. But she didn't comply with it, apparently. Or did she, Mr. Bauer?
She did comply with the recommendations of the drug and alcohol evaluation that was done.
Okay.
It recommended the victim panel. She completed that.
Very good. This is her first revocation, right? First time you had to file a revocation on her, Mr. Bauer?
Yes, Your Honor, this is the first revocation I filed. I just kind of held off trying to get things accomplished, and we were getting close to end of probation, so it was filed.
Well, as far as saying she got the gummy legally as a condition of her probation, I usually tell them to stay away from bars, taverns, liquor stores, places where things are available that she's not supposed to have. And gummies, no illegal drugs, no alcohol. I don't even think she should have been in that kind of an establishment. But it wasn't exactly stated because I hadn't considered that. I will from now on. I'll think about that, but maybe they don't understand. They're not supposed to go buy gummies. And frankly, I won't go into that. But okay, so she knew she wasn't supposed to take illegal drugs, but she thought she would get by with some kind of THC gummy that she bought at the store. She wasn't supposed to have alcohol, but she thought she could take the near beer, as I'll call it, or whatever it was. Although, one thing leads to another. She didn't. When she says NA, on your report, Mr. Bauer, when that says NA, does that mean non-alcoholic? Okay. Somehow she
Yes,
thought.
the NA stands for non-alcoholic, Your Honor.
Okay. So she thought she was drinking a non-alcoholic beverage, but she was positive for, was it beer? In that first test, it was wine in one of them.
She tested positive for alcohol. I can't say exactly what kind, but it was a positive test for alcohol.
Fair enough. Okay. So she had two positives for alcohol, that one, and then the beer with, or the wine with dinner, that was a separate one, right? So it just looks to me, Miss Cowan, your attorney's done a good job, as he always does, arguing for his client, making good points, and I have considered those points, but it just appears to me that you have had income from your B&B, and you've just chosen not to make this a priority, or it just wasn't important to you. You've shown that you can pay it when it comes down to the wire. If you don't want to go to jail, you can come up with money to pay it. You didn't pay it until today. You hadn't paid it when the probation revocation was filed in May. So I find this as a willful not failure to pay, not a situation where you didn't have the money, because you were making the money with your B&B that you were keeping full, you told Mr. Bauer. And so you were keeping it full, making money, but you chose not to pay a dime, not one dime, nothing, in good faith on this case. You could have paid
That's
a
not
dollar.
true.
Well, that's what my records show, and the clerks are pretty diligent about keeping their records.
No, I did pay the 200. That
And
was
when did you pay that?
a month ago.
After the motion was filed, you paid 200 out of your own pocket?
I believe that's when it was. And the Airbnb was not always booked. That was extra money to pay my electric and my water and my bills.
Well, you told Mr. Bauer on several occasions that you couldn't keep appointments because your Airbnb was booked. You didn't have
Yes,
time
there
to
were.
come.
Oscar Flores. It's case number 2026 CR 115. Mr. Flores appears in the office of his attorney, James Watts. Brett Sweeney appears for the state of Kansas. This matter comes before the court at this time for a scheduled evidentiary preliminary hearing. Is there any announcement to be made at this time, Mr. Watts?
Grab my paper here, Your Honor. Your Honor, we are prepared for preliminary hearing.
Very well. I trust the state's ready to proceed, and Mr. Sweeney, you may call your first witness.
Well, Your Honor, I thought I would be ready to proceed. I don't see one of the witnesses that I need, which is the affiant here, Officer Moore. So if I may have just a brief recess to see if I can locate him and find out why he's not in the Zoom conference.
Very well. We'll take a brief recess at this time, Mr. Sweeney.
Okay, thank you, Your Honor. And I think he works last night, I think, but he's trying to get on to the Zoom conference as we speak. We did subpoena him. We sent him the Zoom link last Friday to make sure he had it. So he should have everything and should be on here fairly quickly, but I just wanted to give that update. I would put Officer Weber on, but he's just the dog handler. And honestly, I mean, the majority of the evidence, if not all of it, would be the individual we're waiting on.
Would it be appropriate to go ahead and have Officer Weber testify then?
I mean, I guess we could, and I could just have some testimony from him. I think it'll probably be pretty limited, but we can do that.
All right, very well. If Officer Weber would raise his right hand, the court will administer an oath to him. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
You may question the witness, Mr. Sweeney.
Thank you, Your Honor. Sir, would you please state your name for the court, please?
Michael E. Weber,
And Mr. Weber, who do you work for?
Butler County Sheriff's Office. And
sir, how long have you been a law enforcement officer?
Well, 11 years, 191 days.
Okay, all right. And I'm assuming that you're certified and still in good standing as a law enforcement officer.
Yes, sir.
Okay. And sir, I'm going to direct your attention then to January 18th, 2025 at approximately 2:37 in the morning. Were you on duty and acting in your capacity as a Department of Public Safety officer on that date and time?
Negative. I was a Butler County deputy.
Okay. I am sorry. Sorry about that. And as a Butler County deputy, do you sometimes assist with Augusta and stops that they may have that may require a canine officer?
Yes, sir.
Okay. And that kind of leads me into my next question. You're a canine handler, correct?
Yes.
And what is your canine partner's name?
Canine Lego.
Okay. And when did you first become paired or bonded with that dog? And what are the requirements to do so?
Lego's been on the streets for 4 years and 75 days. We went to Von Lick Kennels. Originally, that's where she was selected from. Went through 6 weeks of training there and then came back and we're certified we've certified all 4 years with Kansas Police Dog Association.
Okay. And so Kansas Police Dog Association runs, I mean, for lack of a better term, kind of an audit to make sure you're in compliance and you have all the paperwork needed to work together as a team in the community.
Yes, sir.
Okay. And to your knowledge at the time and at this time currently, he's still in good standing. You're still in good standing as a canine handler.
Yes.
Okay. Well, let me then direct your attention back to that date that I previously mentioned, which is January 18th. I want to make sure that that date is correct. I believe it was 2025. Well, that's what's in the update here. One second. Yes, January 18th, 2025. Were you on duty and acting in your capacity as a sheriff's officer on that date and time?
Yes.
Were you given any information regarding a traffic stop in the Augusta area? And if so, did you respond?
Yes, I was requested at approximately 02:45.
Okay. And so you were explicitly requested, this wasn't just something you responded to on your own?
Correct.
How far away were you when you responded?
Don't remember exactly. I know I arrived on scene at 02:56.
Okay. And when you arrived on scene, do you have a recollection of what the officer that stopped the vehicle was doing when you got on scene?
Officer Nate Moore was in his patrol car when I approached him. I don't recall what he was doing at that time, but I know he was in his patrol car at the time.
That's fair. Did you have a conversation with him about what might be needed from you and K9 Lego?
Yes, he requested I do a free air sniff on the vehicle that he had stopped.
Okay. And can you generally talk to me about how that works, and then specifically also, I guess, what happened in this case?
For me, I approach the vehicle, take K9 Lego up to the front passenger side of the vehicle, give her command to search, and normally it's on her direction, but normally we go in a counterclockwise direction for the first lap around the vehicle. She instantly started sniffing the vehicle, worked down the driver's side, came around to the passenger side. She stopped at the B pillar at the door, and I kept walking. She continued walking with me, and then stuck her head in the front wheel well of the vehicle, and then went to her ultimate train final response of a sit, and she would not come off the vehicle.
So she had the dog has a passive alert essentially.
Correct. Yes. I mean, she has a change of behavior, but her trained final response is the sit. But even before the sit, she has a change of behavior, which for her, it's often her ears rotate forward and her tail starts wagging faster.
Okay. And in this specific instance, was there any ambiguity or how pronounced, I guess, was the change of behavior of the alert?
It was very pronounced.
Okay. And so once that happened, what did you tell Officer Moore with respect to the dog alert?
I verbally praised K9 Lego off the vehicle, and as I walked back to my vehicle, I did tell the Augusta officers that it was a positive indication for the odor of narcotics.
Okay. Sir, I don't think I have any further questions for you. At this time, I pass the witness.
Mr. Watts, any questions for Mr. Weber?
Very briefly, Your Honor, Mr. Weber, when you arrive, Mr. Moore is the initial officer who stops, correct?
I believe so.
Officer
His Mr. Officer Moore was the first vehicle behind the suspect vehicle, so I
Okay.
believe so.
Were there further officers besides Mr. Officer Moore, other vehicles?
Yes.
About approximately how many?
There are, when I arrived, if I remember correctly, there was at least one.
Okay,
After the sniff, Sergeant Weber was also there.
okay. And when you arrive, I assume you would check in with Officer Moore.
Correct.
Okay. And this may be a little redundant, but when you arrive with Officer Moore, what's he doing?
He's in his patrol car. I don't recall what exactly he was doing, but he was seated in his patrol car when I
Okay.
arrived.
You don't know whether he's writing a ticket or calling in for other information, or he's just sitting in the car, as far as you could tell.
I didn't pay that much attention to it. I approached the car with Lego with me. It was very cold that morning, and I didn't want to be out there very long.
I get that. I do. All right. So I don't think I have any other questions. Thank you.
Is there any reason why Mr. Weber can't be released from the meeting at this time, Mr. Watts?
No, Your Honor.
Mr. Sweeney?
No, Your Honor. Thank you.
Thank you. Officer Weber, you're released from the meeting at this time. If you do stay with it, and you can, please mute yourself.
Thank you, Judge.
Your Honor, this time, say, would call the state's second witness and last witness, Officer Moore.
So Moore, if you'd raise your right hand so the court can administer an oath. You do solemnly swear that the testimony you're about to give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay. May question the witness, Mr. Sweeney.
Thank you, Your Honor. Sir, would you please state your name for the court, please?
My name is Nathaniel Moore.
And Mr. Moore, who do you work for?
I work for the Augusta Department of Public Safety.
Okay. And sir, how long have you been an officer?
I've been employed with the Augusta Department of Public Safety for over 4 years, and I've been on the patrol side for over 3.
Okay. Do you have training in investigation of narcotics cases?
I do.
And you said that you've worked on road patrol for 3 years at this point as of today?
Over 3 years as of today, but at the time of the stop, it was probably close to 2.5, somewhere in there.
Gotcha. Sir, I want to direct your attention then to this particular incident. January 18th, 2025, approximately 2:37 in the morning. Were you on duty and acting in your capacity as a guest police officer on that date and time?
I was.
And can you tell me specifically where you were located and what you were doing?
Around that time, I was on 7th Avenue, which is runs east and west. It's the main highway that runs through Augusta. And I was just driving around, performing normal patrol duties, monitoring traffic, etc.
Okay. Obviously 2:30 in the morning in Augusta, probably pretty dark in January.
Yeah, it's pretty dark, and especially in certain areas that aren't well lit.
Okay. Did you see anything that you felt might have been a violation of the traffic code or anything that required further attention from you?
I did. What about the 500 block of West 7th Avenue? I saw a black truck driving eastbound, and I was traveling westbound. As I drove past it, I noticed that the windows tint on the driver's side door, or driver's side front and rear doors, was extremely dark, and I thought that it might have been outside the legal limit, which is 35%. 35% allows 35% of light to get through. And I flipped around and started following that vehicle, and eventually relayed the vehicle's information to our dispatch center by relaying its license plate to our dispatcher.
Okay. And when you relayed that license information to the dispatch, the Augusta dispatch, did they give you any information regarding the vehicle?
Yeah, they said the registration was expired, and it had expired in 2024. I don't have my report with me, but I remember it was well expired by the time that I had relayed it that evening or morning, excuse me.
Right. So we're in January of 2025, and it's expired in 24, correct?
Yeah. Yes.
Okay. So you've now got this information. What do you do next?
I liked the vehicle, so I ended up following the vehicle. We were at that point on Dearborn, pretty close to the intersection of Main and Dearborn, which is not very far from where I originally started following it. And the vehicle, I lighted up with my emergency lights and conduct a traffic stop. And the vehicle eventually, after it kind of fails, it's not like it's trying to flee from me, but it takes some time for the vehicle to finally stop, but it does eventually stop all the way.
Okay. How many occupants in the vehicle?
There was only one occupant inside the vehicle.
Okay. And who was the driver of that vehicle?
It's the defendant in this matter, sitting in the same room with Mr. Watts in the blue shirt.
Your Honor, let the record reflect that the witness has identified the defendant.
The record so reflects that he's identified the individual seated in Mr. Watt's office as the person that was driving the vehicle. You may
Okay.
proceed, Mr. Sweeney.
Thank you, Your Honor. And when you eventually got that individual's information, was that an Oscar Flores?
It was.
Okay. Did he have identifying information or a license on him?
I do know that he gave me his information. I don't remember exactly how I came across that, but he did provide his information. He did not, although I do remember he did not have proof of insurance on his vehicle, and the registration was expired.
Okay, and that kind of leads me into my next line of questioning. When you stop somebody like this, I'm assuming there's a number of things that you asked for. Did you do that? And were those the only thing that he wasn't able to provide you?
He wasn't. I don't remember about the license, but I do. Like I said, his registration was expired, and I don't remember what he had told me for the reasoning behind that. He also had said that he they didn't have proof of insurance, so I had asked him like license, insurance, and then I told him the reason for the stop, and he wasn't able to provide me with any reasoning. I don't remember the reasoning. He told me his registration was expired, and then he didn't have current proof of insurance. But I don't recall the driver's license. I don't remember if he had a valid license or I know it wasn't suspended, but I don't know if it was. I don't remember the driver's license per se.
Okay. When he's unable to provide proof of insurance, do you mean that he didn't have insurance on the vehicle, or he just didn't have proof there on hand? And did you allow him to search for that?
I told him to keep. I know what I normally would do in those situations. I tell him to keep looking while I go back to my patrol vehicle, but I don't remember exactly what I told him. But I do recall that at some point I do decide that I am going to cite him for said offense. So I don't remember if he said he didn't have it or didn't have insurance, current proof of insurance. But I know he didn't have insurance, is what I should say. I guess he didn't have sufficient means for me to prove that he had insurance on the vehicle.
Okay. Who is the vehicle registered to?
Him, if I'm not mistaken.
Okay. And so when you decide to cite him, as you testified, what do? Do you go back to the vehicle and do that?
Yeah. I go back to my patrol vehicle. At that point, I think I had Officer Sergeant Weber was there with me, and I'm not so sure. I think Officer Cole was there as well. And I went back to my patrol car, started filling out the information on my citations.
Okay. Sir, were you the officer that called for a drug dog and a drug dog handler?
I believe so.
Okay, and just out of curiosity, why?
So I spoke with Sergeant Weber, and given the time, some of the things that his behavior, mannerisms, seemed very nervous. The amount of time it took him to stop was also kind of odd to me, especially if he wasn't. You see a lot of times with people that are, take forever to stop. Sometimes it's impairment, sometimes it's not, but it was just odd. All those combined. Also, my sergeant had told me that they had run-ins with him in the past where he was known to possess or he's had history with our department running from us. He's had history with drug possession charges and stuff like that.
Okay. So at what point during the traffic stop did you call out for the drug dog?
I don't have my report here. I don't remember exactly, but I do know that in between talking with him and sitting in my patrol car, that Corporal Chip Weber and his partner Lego showed up on scene fairly quickly.
Okay. Do you have an approximation on time?
I don't have a time on that. I don't have an exact time on that.
That's fair.
I apologize.
No, that's fair. At some point, were you aware of whether or not the dog alerted on the vehicle?
Yeah, Corporal Weber came up to me after conducting a free air sniff with Lego, and came up to me and told me it was a positive indication. But I don't know how. That's all I was told was positive indication that there was on the vehicle, is what I was told.
Sure. And so there's a positive indication on the vehicle. When you were alerted that there was a positive indication on the vehicle, do you remember if you were still writing the citation or not?
I remember that I was still inside my patrol car and I was in the process of writing because originally I planned on writing multiple citations to Mr. Flores.
Okay.
I don't remember all the citations, but because of the difference, window tint is an infraction. No proof of insurance is technically a misdemeanor, so they have to go on separate citations. So I couldn't just put them all on one ticket. I had multiple citations.
Yeah. Well, when you write a window tint infraction, don't you have to, did you check that with the tintometer?
I did not because eventually when I went to look inside my patrol vehicle, I couldn't find my tint meter.
Okay. Just gonna move on from this. At some point, was the vehicle searched, and did you help search the vehicle?
It was.
What of note was found inside the vehicle, and as much description and as specific as you can be, location-wise?
When searching the front, like up by the driver's seat and passenger seat, there's a little cup holder or a little area underneath like the radio. There was a black screen, touchscreen cell phone there. I flipped that down, and behind it there was a small Ziploc baggie with a white crystal-like substance inside of it. Based on my professional training and experiences, I suspected to be methamphetamine based on its packaging, the way it was concealed behind the cell phone, and then the way that it was colored and shaped. Along with that, or behind the passenger side seat, we located several Pyrex pipes, glass Pyrex style pipes that were collected ultimately as drug paraphernalia. And then there was something, I feel like there was something else that, but those are the main items that I remember specifically locating.
Okay. Sir, do you have your affidavit with you?
I do. It's on my phone.
Okay. Uh, okay. And when you talk about a Pyrex pipe, have you seen items like this before in close proximity or in connection with illegal narcotics?
I do. Yeah, I have. Yes.
What about specifically methamphetamine?
It's probably one of the most common with methamphetamine. Out of all of the illegal narcotics, a Pyrex pipe, a glass Pyrex pipe is the most common when it comes to the usage of methamphetamine based on what I have experienced in my training and experience.
Okay. And we're just so I'm clear, those pipes, the suspected methamphetamine is in the front recess under the radio, right?
Yeah, and a little cubby hole with the phone you wouldn't be able to see it if you didn't move the phone.
Right. And then the Pyrex pipes are behind the passenger seat.
Yes,
Okay.
in the rear.
Do you remember if they were burned as if they had been used or not?
I know that for sure some of them weren't. Some of them were inside of a styrofoam, like almost like they were freshly purchased. But I don't remember. I don't remember off the top of my head what the condition of every single one of them were. I just know that some weren't burnt. I do know that.
All right. Gotcha. Do you remember if there were any scales or anything else of note inside the vehicle that might have possibly inferred drug usage?
I do know that there was some other items located. I just don't remember exactly what they were, and I don't want to guess on this.
That's fair. Did you have a chance to speak with the defendant, Mr. Flores, after finding any of these items?
Uh, yeah, and when we came back to the station to process him, there was a little bit of interaction between there and at the station, on scene and then out on the station.
Did he say anything of note about the vehicle and or any of the items that were found inside the vehicle?
No, nothing that he did mention the Pyrex pipes that were unused, asked how they were considered drug paraphernalia if they were clear and or hadn't been used, but I don't remember him ever saying anything about like he never said that was his drugs. He did ask about a friend of his just up the road if she could come get his vehicle, but outside of that, I don't recall.
Okay. So he had questioned you about what the ultimate disposition of the vehicle on the roadway was going to be.
Yes.
Okay, gotcha.
And he had asked, if I'm not mistaken, Kimberly Wood is her name, who lives on Dearborn, a couple houses down from where he officially ultimately decided to stop his vehicle.
Gotcha. Your Honor, may I have permission to share my screen? I've got a what's listed as State's Exhibit number 1 on a KVL laboratory report.
You may do so.
Thank you, Your Honor. Mandy, I sent a request to be able permission to share.
It should allow you now.
Okay, thank you.
This is in the District Court of Butler County, Kansas, in the matter of the marriage of Taylor Marie Beatty and Bryce Robert Beatty, case number 2025 DM 254. Petitioner Taylor appears on the Zoom meeting herself, separate from her lawyer, Sarah. Rick Thompson appears on behalf of the respondent. This matter comes before the court at this time for determination of status. This is a case, counsel, that's been pending more than a year. It was announced back in November that settlement was likely. However, that obviously hasn't taken place. Mr. Thompson, can you give me your view as to what the current status of the case is?
Your Honor, Ms. Newell provided a journal.
Okay, where's the background of this coming from? Because I need that shut down. Okay.
Okay, thank you. Thank you, Your Honor. May it please the court. Ms. Newell sent me a revised journal entry, I believe midsummer. There are a handful of modifications to that. Unfortunately, through no fault of Ms. Newell's, no fault of Ms. Newell's, I have been incapacitated. I injured myself in July. In the hospital for 3 days. I'm in the office now 3/4 time, and that just started yesterday. So there is delay. It is completely on me, and I apologize. I'm in this attire because I had an appointment related to that. I may have to have additional surgery. I find out in 2 weeks, but I have been out of sorts for a couple months, Your Honor. So and Ms. Newell's been very gracious, but the delay is completely on me. I have some information from my client I need to process, but the court knows you get backed up, Your Honor, and unfortunately I was not able to keep up.
All right. I know you'll be straight with me on this, Mr. Thompson. You said that there's a handful of modifications. I trust that none of these, in your opinion, would be so much that would essentially undermine the entire settlement process?
There is one, Your Honor, that I briefly discussed Ms. Newell, what I deem a carve out on that issue to set that possibly for an evidentiary hearing on down the line. And that involves parenting time. So in my pointy little head, what I think we can do is get get the property issues resolved, carve out parenting time if we need a hearing on that, Your Honor. That's where I think I'm at based on the communications I received from my client. I have not had a chance. I just got this yesterday at 4:55. So I have not had a chance to visit with him about the additional information he provided me. But my quick review, that's where I see it, Your Honor.
All right. Given your current situation, what time frame is envisioned here?
It all depends when I see my orthopedic surgeon in 2 weeks, Your Honor. I've got there's some issues with my shoulder that may require additional surgery, and if that happens, Ms. Newell and I had a long conversation about that. Her family was involved with that. I may be out for 2 to 4 weeks, and I won't know that until. Long story short, they're trying to do the conservative treatment with physical therapy. If it doesn't take by the time I see the orthopedic in mid-September, then they're going to schedule me for surgery. The intended then. So I won't have a good answer until mid-September. I'm sorry, Your Honor.
Well, I want to set this case for another status conference, but I'm just trying to determine what the most appropriate time for that would be. It sounds like that perhaps over the next couple of weeks, some progress can be made regarding most of the issues in the case, and perhaps have those issues finalized, even if something does need to be carved out for an evidentiary hearing. So would a September review be appropriate? Mr. Thompson, second
Yes,
half of September?
Yes, Your Honor, second half. Let me make sure I've got my dates right. Yes, Your Honor, like the week of the 21st or the 28th, Your Honor. That will be after my appointment.
Okay. Counsel, if you look at your calendars for Monday, September 21 at 11 o'clock.
I am available, Your Honor.
Ms. Newell?
Yes, Your Honor, Yes, Your Honor, I'm trying to look at my calendar and do everything on my phone at once, and it's proving challenging.
Okay.
Judge, what was that time?
11?
I have an 11 scheduled, I'm sorry.
Okay, then you need to tell me what is open then on that date.
Okay. 9 a.m. or the afternoon after first appearances? I could do 9 a.m.
Yeah, I could as well, Your Honor.
All right. September 21, 9 o'clock a.m. for Zoom status conference.
Your Honor, if I may interject, this is Sarah Newell for Taylor Beatty. Do you bifurcate these? My client would like to have a decree of divorce entered. We're on top of the property settlement and the parenting time issues. Would that be possible if I sent Mr. For you to divorce the parties today?
No.
Okay.
No, let's resolve this case all at once, counsel.
Okay.
I understand the request, but the court denies the request. I want to get this matter completely finished.
I understand.
And we're working toward
Okay.
that. And I know, Ms. Newell, it's not you or your client's fault that there's been a delay, but I also can't hold Mr. Thompson too accountable under these circumstances. I'm willing to grant some latitude here that I normally wouldn't.
I understand. And Your Honor, it's quite possible that if we don't have something finalized by the 21st of September, I will probably make the same request again.
Understood.
Okay.
All right, September 21, 9 o'clock a.m. for further status conference. I encourage the parties to communicate as much as possible, try to resolve as many issues as possible, perhaps even everything involved in the case. So perhaps an appropriate announcement and finalization can take place September 21. So good luck in that regard, counsel.
All right. Thank you. All right. Thanks, guys.
Further at this time, good luck with all your medical issues, Mr. Thompson.
Thank you.
Mhm.
There's nothing
Bye.
further.
That Social Security money's going into a separate account and you're spending it. I don't know how they're gonna collect it if you have no other assets. Do you understand what I'm telling you?
Yes.
Okay. So why don't you still go in and talk to Mr. Tetro and see if you guys can resolve this in any form or fashion, okay? Doesn't make any sense for a lawsuit to go on if everybody agrees that you owe $13,816.90.
The amount is correct because of my financial situation.
No, sir, I understand. You're not the first that's having financial problems. I get it. I understand. So why don't you go talk to Mr. Tetro? My court officer is going to take you to a computer. He'll put you online with Mr. Tetro in a breakout room. We'll put you in. You guys can talk, okay?
So, may I make a comment?
Yeah.
I've been assessed by Wayne County last month. My total monthly income, because I requested food assistance last month. So I was assessed by Wayne County. I have a breakdown of my total monthly income.
Nobody thinks you could pay this. You convinced me you can't pay this.
Because of the fact that I don't have any assets,
You
just one used vehicle,
Sir,
I
sir,
want to go with
sir.
judgment of proof.
Listen to me. They're not gonna just let it go. They're gonna want a judgment. And now the question is, can you pay?
So
Listen, please listen, please listen. They're not just gonna dismiss the case. They're going to want a judge. Now, if you don't have any assets, they can't collect on it. You understand what I'm saying?
Social Security is my only income.
I heard you. Did you hear what I just said to him? He can't collect on that. He knows that. He knows he can't go into your accounts and start garnishing Social Security benefits. Okay? So,
Yes.
other than them having a piece of paper that says that they've got a judgment against you, I don't know what more they can get. But I have no authority to dismiss the case. They're going to want a judgment. I'm suggesting that you go talk to him in that room and speak to him. Okay? You understand what I'm saying? You don't understand what I'm saying? I'm asking
Your
you.
Honor, I understand what you're saying about going and talking with him in the room. And after the conclusion of this conversation, where am I at?
You guys are probably going to enter into a consent judgment, which he's going to get anyway, because you just agreed that you owed the debt. Well, listen to me.
I don't understand what that means.
Okay?
Consent judgment.
That's fair. That's fair. If you agree to, they are going to present the court with a judgment that's signed by both of you that indicates that you owe $13,816.98 plus whatever court costs he has. And then that's like a piece of paper that says plaintiff has a judgment against the defendant for $13,816.98 plus his court costs of probably another couple $100. But now the question is, can they collect them? And I don't even think you need an installment payment order because you don't have any funds that they can attach. You're not working, right?
I'm retired.
Right. You don't have, he can't garnish your wages. He can't garnish bank accounts that consist solely of Social Security benefits. So they're pretty much out of luck. Does that make sense?
Yes.
Okay. I'm just saying, go talk to him, see if you guys can at least agree to submit to a consent judgment. We can put this to bed today. And then, I don't know.
Will you tell me what a consent judgment is?
It's an agreement between the two of you that the plaintiff has a paper judgment that says that Capital One is entitled to collect against you the $13,816.98 plus their court costs. It means nothing more. If you agree to sign it, if not, he's got to jump through hoops, and it doesn't make any sense to me that you'd require him to do that since you've acknowledged you owe the debt. Do you understand what I'm saying?
Yes.
Go talk to him. I'll put the file aside and you come back in here, okay? You understand what I'm telling you? Yes?
Yes.
Okay, I'll see you in a few minutes. Mr. Petro, he's gonna take him over there right now. Thank you.
Thank you, Judge. I'm sorry, Your Honor. I have a 9:30 just to put you on notice.
That one, Mr. Clark is on that. Defendant's counsel is not checked in and he is in a breakout room with another matter.
Genesis Credit versus Jason Wilson, 2602095.
Yes. Good morning, Your Honor. Margot T. Mammoth, PA 1102 on behalf of plaintiff.
Right. Sir, your name?
Jason Wilson.
All right. You filed a motion to set aside default. You want to proceed with that?
As of now, yes, sir.
Go ahead.
Your Honor, I'm asking the court to set aside the default judgment because I dispute both the validity and the amount of the alleged debt.
Can you keep your voice up for me nice and loud?
Oh, I'm sorry, sir.
That's okay.
On May 27th, I sent Holzman Law a written request for verification. I specifically disputed the debt and requested documentation establishing the amount claimed and the basis for the deficiency. I did not receive that verification.
What did that have to do with you not answering the complaint, though?
When I got a message back from the law firm, they said they would have 30 days to respond. And
But you didn't file an
that
answer
put it
to
on hold.
complaint.
Oh, I'm sorry, sir. What was that?
You did not file an answer to the complaint, though, did you?
No, I didn't. I was waiting for the response. And then I got the response after I got the documentation that I did not appear. And then that's when I filed this judgment.
Counsel, what do you have to say? What is your position on this?
Your Honor, in order to set aside default judgment in Michigan, the defendant has to show good cause and a meritorious defense. The defendant was personally served with the summons and complaint May 16th of 2026. He did request information from our office May 26th, 10 days after he was personally served. So one, that shows he was served and he had actual knowledge. That removes any possibility of good cause for failing to appear. He's presented no meritorious defense to that. If he believes that we were required to provide him any more than was required or that we have provided, at that point, litigation was occurring, and this court had not opened discovery. He's more than welcome to request anything. However, the 30-day validation period he's referring to is under the Fair Debt Collection Practices Act, which begins to run from our validation notice, which was actually sent in December of 2025, to the same address that's on his current motion. He also disputed the notice of intent, and he wanted personal effects out of the piece of property that was sold. The notice of intent to sale and the notice of sale itself were both sent to that same address in February and March, respectively, of 2025. Again, the defendants failed to show both good cause and a meritorious defense, and he needs both in order to set aside the default judgment. I ask that the court deny the defendant's motion.
Sir, do you owe this debt?
Yes, sir.
You owe the debt?
My meritorious defense is that I dispute the amount based on the alleged deficiency, including whether the plaintiff has properly established the debt.
I'm asking you, do you owe the debt? How much do you owe?
According to the paperwork I received, like around 19,100, I thought.
Asking you how much you think that you owe or owe.
One second, sir. I was looking at like a difference of $8,225.
Do you think that you owe? I'm asking you for a figure right now. How much do you think that you owe?
I was looking at around 13,000.
There's no arounds. The beauty about math is there's only one right answer, and we get it to the penny. I'm sorry, I didn't turn my camera on. My apologies. That's the beauty about math. So I want to know how much you owe according to you. The exact figure.
I don't have that in front of me right now, sir.
I can't find there's a meritorious defense, and I can't find that there's good cause, and I need both. You were served, according to plaintiff's counsel, on May the 16th. The default judgment was not entered. The copies that I have are a little, it looks like June the 25th. So I'm sorry, I'm going to deny your motion. Defendant's motion to set aside the default judgment is denied. My apologies to you, I guess, but that's what I have to do. Good luck to you, sir. If you want to file a motion for installment payments, I'll be more than happy to entertain that. Okay, you can file a motion.
So I have to come in front of go down and file for that motion of.
Why don't you do this? Mr. Mamet, do you have another case in front of me this morning?
I do not, Judge.
why don't you go into a breakout room with Mr. Mamet? Explain your financial position to him, where you work, what your income is, what your bills are. And you two can just figure out if you can stipulate to an order regarding installment payments. Something that's not going to,
Oh, sorry, sir.
something that's not going to bankrupt you or cause you to not be able to eat, but it's fair to the plaintiff. They've got a judgment for close to $18,000 here.
Yes.
Okay, so
We
we'll put
did
you in
have
a
a
breakout
breakout
room
session before this.
right now.
And I told
Right.
them I would be able to afford $200 a month.
What about that, Mr. Mamet?
Your Honor, as I explained to the defendant, unfortunately, I don't have the authority this morning to accept that. However, now that it's on the record, should the court order it, that would be
Where
the
do you
order of the
work
court.
at? Let me ask you to raise your right hand, Mr. Wilson. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, I do, sir.
Where do you work at?
I work at BASF and Wyandotte.
Okay, so you're making good money. How much did you make in 2025?
Roughly, I think around 120,000.
Wow,
That
good for
was
you.
net pay. Net pay.
What do you
Oh,
mean net
I'm
pay?
sorry, gross. Gross. pay.
Gross, I get it.
Yeah.
All right, unfortunately, we all have to pay taxes. What kind of bills do you have, sir?
I got a house payment of $1,745 a month.
Okay,
Car payment of $500.
okay.
Insurance is $800 a month.
$800 a month for car, what, for car insurance?
I have multiple vehicles on it.
Okay, go ahead.
My DTE payment is $520.
Well, that's
For
a lot.
gas.
Where do you live at?
Brownstown.
How big's your house?
Like 2,000 or
Yeah,
no,
you're not paying $520 per month for 12 months. I
23.
just got mine was $520, but that was because of the air conditioning, right? So anyway, you
Yeah,
can.
I'm on a
Go
budget
ahead.
plan at $520 a month.
Wow, maybe you need to rethink that, or I don't know what you put your thermostat at, but go ahead.
Of course, I have my DirecTV and AT&T 167,305.
What do you mean,
And,
167,305?
Oh, I'm sorry. DirecTV is 167 a month. AT&T for cell phones and internet and everything is 305. And then I have a credit card payment of 140 a month.
And you have to get food. Are you married?
Yes, but I'm under the assumption that this is just taken in my income, not my wife's.
Well, I mean, there's truth to that. I'm just asking if you're married. Does your wife work?
Yes, she's a school teacher.
How much do you make? So you guys got to maybe budget your money better. I don't want to sit here and lecture to you about that, but if you're making over $200,000 a year.
I'm not disagreeing with you with that.
All right. You want to ask him any questions, Mr. Mamet?
No, Your Honor. However, again, if the court would order it this morning, that'll be the court's order. I can't accept it.
I'm going to do that. I'm going to order defendant to pay $200 per month. Can you start on the first of the month?
Yes, sir, I can.
All right. Installment payment order. Counsel, I'm going to ask you to send me one. Defendant to pay $200 per month beginning September 1 and the first of every month thereafter until paid in full. This order is subject to review on motion of either party January the 31st. On or after 131 of 27. Okay?
Yes, sir.
So stay with that, and they cannot garnish your wages. They still could garnish bank accounts. They still could garnish tax return, but they cannot garnish your wages, okay?
Okay.
So make sure you get that to them by the first of the month. Do you need to go into a breakout room and tell them how the payment should be made, Mr. Mamet?
Yes, Judge, we can do that.
We'll put you into a breakout room. Thank you, gentlemen. Good luck to both of you. Thanks, Mr. Wilson.
Thank you, sir.
American Express. I'm sorry, did you say something?
Yes, Judge. Sorry. Would the court like plaintiff to submit the order denying the motion and the motion
I
for
would.
installment payments?
I would.
Excellent. Thank you, Judge.
Thank you very much. American Express versus Kenneth Brown, 2602167. Who do I have for American Express here?
Good morning, Your Honor. Cezanne Barta, P65425.
Good morning, Mr. Barta. How are you today? Good?
I'm wonderful. How are you?
Good. Where is Mr. Brown at? Is he out here somewhere? There you are. Mr. Brown, your name? I thought I just, Mr. Brown, you have to start your video and tell me your name, please.
Hi, my name is Ken Brown.
Good morning, Mr. Brown. How are you?
Good, how are you?
Did you two talk and try to resolve this, Mr. Barta?
We did, Your Honor.
Any resolution?
No resolution at this time, Your Honor. We're kind of in the exact same situation as we were in the prior matter, in that today's the day and time set for plaintiff's motion for summary disposition. I don't believe there's a response filed. I don't believe Mr. Brown's disputing. We're just trying to get it resolved. American Express has some strict and tough guidelines in how much time debts have to be paid off. And because of the amount and that time duration, we're looking at $650 a month is the lowest that I can go.
I got it. Thank you. I get your directness here.
Yeah.
Mr. Brown, do you owe this debt? He's filed a motion for summary disposition.
Yes.
So do you want to add anything? Otherwise, I'm just going to find there's no genuine issue as to any material fact. And we're going to put the figures on the record, and then I'm going to entertain the motion for installment payments. So you want to go ahead and do that? So I'll just indicate motion for summary disposition granted. There's no genuine issue as to any material fact. And I'm going to allow you to go ahead and set forth your figures.
Your Honor, there is an order attached to our motion, and the damages are $24,066.82, plus just the court costs of the filing fee, the service fee, and the motion for summary disposition fee, which come out to $227.76 for a total judgment amount of $24,294.58.
Jennifer, do you have that order? I don't see it
I
attached
do,
to
Your
my-
Honor. It's in my pending because it was a separate
That's
document. And I
fine.
can send it to your box for signature.
Perfect. So we have 2406682, plus we have 22776 total, 29294.52. All right, so I'm gonna enter a judgment in that amount, Mr. Brown, okay? Now, I'm gonna swear you to an oath, so you don't have to come back. And we're gonna have a hearing on installment payments, all right? So I'm gonna ask you to raise your right hand, please. Do you solemnly swear or affirm? Let me see your hand, please. Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, I do, Your Honor.
All right, sir, could you tell me where you work and how much you make? And then you're going to follow up with what bills you have.
Okay, do you need me to present that information now?
Yeah.
Okay, the figures I don't have, like off the top of my head, I'd have to get those.
Where do you work?
But I am self-employed.
Okay.
I suspect probably the figures right now for like how much I make.
Yeah. How much did you make in 25?
25, I think it was 65,000.
Are you sure?
I would need to get that information. I'd have to pull that up.
How much can you afford to pay weekly or bi-weekly or monthly?
Monthly, I can comfortably pay around 600.
All right. Can you live with that, or did you say 650, Mr. Barta? You're muted.
Your Honor, I can live with that.
All right. So here's what I'm going to ask you to do. I don't need to go through anymore unless you want to ask him questions, Mr. Barta.
No, Your Honor, I'm fine with that. I just want to make sure that he's comfortable, that he can make those payments and he's not going to default, because
Right.
if he needs some latitude and leeway, you can order something else.
So I
Okay.
want to be clear, Mr. Brown, I certainly don't want you to, nor does Mr. Barta want you to not be able to eat or go into bankruptcy. So truthfully, I'd rather you err on the lower side than the higher side. You follow me? That's $7,200 after tax money per year. Can you afford that?
Yes, I can, Your Honor.
You're sure?
Yes.
All right. Defendant to pay $600 per month beginning September 1 of 26. This matter is subject to review on motion of either party on or after January 31 of 27. I'm going to ask you to prepare all of this, Mr. Barta. And remember, as long as you make those payments as agreed upon, they cannot garnish wages. They can garnish bank accounts, they can garnish tax returns, they cannot garnish wages. And whether you're the
Your Honor,
employer or not,
it is our office policy not to file bank garnishments on installment payments that are timely.
so you got that? They're not gonna garnish bank accounts either.
Yes.
All right. So just make sure you make those payments as I just ordered, 600 per month, beginning September the 1st and the 1st of every month thereafter. Order subject to review on motion of either party on or after January 31 of 27. So let's say something happens. I don't know. What do you do for a living?
I run a digital marketing agency.
Okay, so I mean, I don't know you never know what's gonna happen with the economy. If your wages go down, you can file that motion on or after January 31, okay?
Okay, thank you.
Mr. Barta, anything else, sir?
No, sir, I have another one at 9:30 with you, so I'll hang around.
Okay, thank you.
Thank you.
All right, now I have First Choice Homes versus Talera and Myron Mosby. Myron Mosby and Talera Mosby. Are either one of them here or on Zoom? This is 260-2602.
Miss Mosby is on Zoom, Your Honor.
And good morning, Judge. Jeremy Piper for the plaintiff.
Ma'am, your name?
My name is Talera Mosby.
Where's Mr. Mosby or Myron Mosby at?
He is sick. He's a diabetic. His blood sugar is high, so he did not attend the hearing today. Due to that, he's fatigued and he has to wait for his blood sugar to come down. He took his insulin.
All right, what do you want to do, Mr. Piper? You want me to go ahead with the pretrial?
Yes, Judge, we did have a chance to talk in a Zoom room, and we would just request a regular scheduling order with a trial date and or a final pretrial date, and we're going to try and resolve it.
Good enough. Just let me make some notes here, please.
And Judge, while you make notes, I just would say for the record, the defendant's answer that was filed in this case basically referred to a bankruptcy filing. We were unable to locate a bankruptcy filing other than one from 2023, which was discharged. I did talk to the defendant. She indicated that they will not be filing bankruptcy, and so we don't have to worry about that for this case.
Is that true, ma'am? You are not in bankruptcy now?
No, I'm not. After we sat down with our attorney, we're going to do a different way, of course, and try to resolve the matter outside of filing bankruptcy.
Okay. CD on Myron Mosby, we're just going to make a appearance line not present due to medical condition. Okay. All right. So I'm going to go ahead and Mr. Piper, what is your P number, please?
Sorry, Judge, 63008.
All right, I'm going to give you discovery. Is that what you guys want? Is discovery? You want discovery?
We don't request it, but if that's normal, that's fine.
Ma'am, can I just interject here? I can order discovery if they have something that you think is going to help you. If they have documents that you want that you think are going to help you. If this is just a question, though, of you owing the debt, well, this is a mobile home, right?
It's a purchase of a mobile home, yes, Judge. That got delinquent.
How are you going to be able to pay? Or how delinquent is she, counsel?
As of last Friday, the arrearage is $5,218.
What do you think the value of your home is, ma'am?
Probably 70,000.
All right, so we want to make sure you can pay that. You gonna be able to pay that so you don't lose it? I mean, if that's all you owe is 5,200 and some, what is the total amount of the debt that she still owes? That's the arrearage right now. What's the total amount of the debt that they still owe?
$61,576.
So you don't want to lose. You got $8,500 at roughly in equity. If it's $70,000, you don't want to lose that. Why don't you figure out a way that you can come up with the money? Can you think you can do that?
We've been working on doing that by attempting to pay more than our mortgage amount. It's just been a hardship because of my husband's pending disability case with the state of Michigan. So with that monthly reduction, $3,000 to $4,000 per month is why we fell behind. But we have made good faith payment in making monthly payments to the 765, and then because we can pay like $1,000 per month to try to catch it up in the
Here's what I'm
meantime, and
gonna
then
do.
so
Here's what I'm going to do. I'm not going to grant discovery. It sounds like this is pretty cut and dry. What I am going to do is set a trial date out there a ways. We're not going to have a settlement conference. Jennifer, I'm going to put 1/2 hour for trial. We're going to set a witness list. You have to file your witness list by October the 30th. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. Jennifer, I would like a trial date for the latter part of November, okay?
Okay, Your Honor,
Counsel, you're gonna give them a little bit of time to try to resolve this, right?
Yes, Judge. We haven't had any substantive talks because we were told there was a bankruptcy. So we're happy to engage with the defendants, and I already got their email and their phone number to do so.
Good. Discovery, I'm not going to allow discovery. If somebody decides they want discovery down the road, they can file a motion for it. We're going to set the trial date. Do you have any idea when your husband's disability case might get concluded? I trust you have a lawyer, right?
we have an appointment tomorrow, or when is it? It's the 26th at 2 p.m.
Okay, that's in a couple
They
days.
need additional medical information.
Not September, right?
No, not September. This is an appointment to follow up. They needed additional medical information, so we
In
have
2
to
days,
see how
right?
that
August
goes.
26th?
Right.
All right,
Yeah,
give me a
that's
date
right.
at the end of November, Jennifer, or early December, whatever you want.
we have December 1st, Your Honor.
12/1 and at 10:30, is that good?
10:30, yes.
All right. I wish you well, ma'am. I really do. December 1 at 10:30. Mr. Piper, anything else?
No, Your Honor. Thank you very much. And Miss Mosby will be in contact with you. Thank you.
Do you have another case pending with me, Mr. Mike Piper, here today?
No, Your Honor, I don't.
Have a good day. Good luck
Yeah,
to you, ma'am.
you
Thank
too.
you.
Thank you.
Thank you. Bye.
Did I call Capital One versus Zambeck again? Capital One versus Zambeck and Zambeck, 2505264.
Good morning, Your Honor. Dylan Clark, P88474, here on behalf of plaintiff.
Do I have the lawyer for defendant?
No, Your Honor.
You know, one thing, Judge Smith, that I noticed a difference in? No judges called me when I was a lawyer and said, get on the line, right? Now we got to do this every week, it seems like, multiple times. Give them a call, will you please?
Yes.
Heather, tell them,
Yes, Your
or
Honor.
Jennifer, tell them I need them on the line, please. Capital One versus Chris Benton, 2602604. You can come on up here, sir.
Good morning, Your Honor. Andrew Tetro, P79743 for the plaintiff, Capital One.
Your Honor, I apologize. They have not spoken. I didn't know the defendant was in the courtroom.
That's okay. Sir, your name?
Bruce M. Becky.
All right. This is
So if I'm still in the breakout room,
no problem. Sir, he has another court date too, so just be patient in there, okay?
Mr. Tetro, can I ask what case that was that you have at 9:30?
yes, it's 26-01151 GC.
Okay, I do have defendant's
You have
attorney
that?
here on that.
Do you have that one?
No.
Oh, here it is. Edward Mann versus Thompson's Appliance. 260096. Do I have somebody here from Thompson's Appliance, the agent?
No, Your Honor, they have not checked in. There was alternate service on that.
Is Thompson's Appliance, is Thompson's Appliance still doing business at 32414 West Jefferson, to your knowledge, in Brownstown, sir?
To my knowledge, yes. And I believe it's also the residents that go out of business.
And it was returned, Jennifer.
Yes, Your Honor, unclaimed is what I'm seeing.
So 4 trips of attempted service from Dino.
I know, but if they don't live there, that's not very good for me to start issuing warrants for people's arrests. You follow me?
Yes.
I mean, I gotta be fair with them too, even though he hasn't paid. That's terrible. Have you ever tried to do a little bit of research and find out where Adolph Thompson lives now?
The address I found was the same as his business. When I actually saw him at his house.
When?
I was driving, well, I went to,
How long ago?
I don't know, but when he was, when I was initially texting him and calling him to try to get my payments, so I wouldn't have to go through all this. I just kept getting ghosted. So I was able to find the address of his business. And I went to his house there to just talk to him, to see if I could get the money there.
At 32414 West Jefferson?
Yes.
Thing that troubles me is it was well, he might have just not signed for it, right?
Yeah. Your Honor, it does
that's
look like
mine.
the envelope is showing that they left multiple notices. And then after multiple notices, they return it to us unclaimed. So they probably, so someone didn't go pick it up at the post office.
All right, here's what I'm gonna do. He failed to appear for a creditor's exam. I did give you an order for alternate service. I'm gonna have you issue a show cause order. I'm gonna issue the show cause order. They're gonna help you out with the paperwork downtown. We're gonna reschedule this. If he doesn't show then, I'm gonna issue a warrant for his arrest. So Jennifer, reschedule that, give him the order for show cause. It can be served by first-class mail at least 10 days before the scheduled date. Can be served by first-class mail at least 10 days before the scheduled date. I mean, it's only $340 some, right?
Well, yeah, but now because of all.
No, I get it. I'm not suggesting you shouldn't try to collect it. 33125 is what the judgment was for. Now you got extra expenses.
Yeah,
That's how I'm going to handle it, okay?
Okay.
So you go down the hall, they're gonna give you a new date, you're gonna prepare, they'll tell you what to prepare. I'll sign the order for a show cause. If he doesn't show up, I'm gonna issue a warrant for his arrest. Okay?
Yes.
All right, sorry you have to go through all this. Best of luck.
Thank you.
That
How did the warrant for his arrest do anything?
goes into lien, he gets picked up for something or stopped, they're gonna haul him in,
Okay.
okay?
All right.
Thank you. Doctors Harris, Burkill, Wang, Song versus Katie Elizabeth Callahan, 2602165. Good
Thank you, Your
morning,
Honor.
everybody.
Morning, Your Honor. Hal Burke, P69068, attorney for the plaintiff in this case.
Good
Leslie
morning.
Kemp. Good morning. Leslie Kemp Smith, P number 35218, appearing on behalf of the defendant, Katie Elizabeth Callahan.
What are we doing on this one?
Your Honor, we had a very cordial and pleasant conversation in your breakout session. Two things. One, I still am putting together the itemized statements that Attorney Smith asked for. There's one missing and I just asked my assistant to get it today. And in the meantime, I don't want to speak for her, but Ms. Smith made an offer on this case that I'm also going to review with my client.
But I adjourn it another 3 weeks. Is that good?
Perfect.
Yes.
Yes, please.
Okay, let's adjourn this 3 weeks, Jennifer.
Your Honor, let's go with September 22nd at 8:30.
At 8:30. Of course she'd be pleasant, Mr. Burke. She was a judge. We're all pleasant, aren't we?
I agree. No dispute there for sure.
Have a good day, you two. I'll see you on the 22nd.
Thank you.
Thanks.
And
Have a
thank you,
great
Mr.
day.
Burke.
Thank you.
Jason Serafovich, Citibank versus Jason Serafovich, 2602248.
Good morning, Your Honor. Dylan Clark, PA 8474, here on behalf of plaintiff.
Sir, your name? You have to unmute Mr. Serafovich and then tell me your name, please.
Good morning, Your Honor. Jasmine Serafovic.
All right. Did you two talk in a breakout room?
We did, Your Honor, and we did come to a resolution. Mr. Serafovich is withdrawing his motion and will be entering into a consent judgment.
Okay, you want to give me the terms of that?
Sure. Mr. Serafovich has agreed to make monthly payments of $198 towards a total judgment amount of $11,871.89. That's represented by damages in the amount of $11,584.37, court costs in the amount of $212.52, and a statutory attorney fee in the amount of $75 with no interest accruing. First date of payment will be September 15th, 2026, continuing on or before the 15th day of each month thereafter till the balance is paid in full. And Mr. Serafovich has provided his email address so that I can forward him the consent judgment for his review.
All right, so he's going to pay $198 per month beginning when?
September 15th, 2026, continuing on the
All
15th.
right, sir, you withdraw your motion to compel arbitration?
I do, Your Honor.
So motion is withdrawn and dismissed, and this will be in the form of a consent judgment that calls for a total to be paid of $11,871.89 at the rate of $198 per month beginning September the 15th. Is that your understanding, Mr. Serafovich?
Yes, Your Honor.
Do you want to read this, or does Mr. Clark simply have your permission to sign your name to this proposed consent judgment? It's right on record here with all those terms.
That's fine, Your Honor.
You consent to him signing your name to that proposed consent judgment with those terms set forth therein?
Yes, Your Honor.
Okay. All right, so you can submit that, counsel?
All right, yeah, I can sign that on behalf of Mr. Serafovich. And then
We're all set unless somebody has something else to bring up here.
I think that does it for this matter, Your Honor.
All right, have a great day, Mr. Clark, Mr. Serafovich. I wish you well.
Thank you, sir. I will.
I do actually have a couple of matters in front of you, including that
Okay.
motion for summary where the opposing counsel is not here.
Okay. Has Ann Zambek's attorney shown up?
No, Your Honor, and I called and all I was able to do was leave a message, but I do have an attorney. If you give me Mr. Price.
Yes, I believe we are having a communications issue at my firm.
Yeah, I was
Yes.
just trying to figure out what case you're appearing
I'm
on.
trying to
the
figure out
case
too.
number.
I believe Attorney Zagararis is here for me, so I can just
Oh,
go.
okay.
Oh, but let me call this Capital One versus Ann Zembek, 2505264.
Dylan Clark, PA 8474, here on behalf of plaintiff.
What do you want to do on this?
Your Honor, I'd like to proceed with the motion for summary.
I'm just surprised that I got a lawyer that's just not showing up at all. I mean, all right, give me 1 second. Go ahead. You can proceed with your motion for summary disposition.
Your Honor, this is plaintiff's motion for summary disposition brought under MCR 2.116 C9 and C10. Attached to plaintiff's motion are account statements, a cardholder agreement, and an affidavit of plaintiff's custodian of business records satisfying all the requirements of MRE 8036. The statements attached to plaintiff's motion were sent to the address where Ms. Zambek was served via personal service. By looking at the statements, you can see that the last payment made on the account was in July of 2024, July 15, 2024. The last purchase on the account was made November 30th of 2024 before the account was finally charged off in February of 2025. The statements show that Ms. Zambek made purchases and then made payments in response to those statements. There's no genuine issue of material fact here, and my client's entitled to judgment in the amount of $3,014.16, representing damages in the amount of $2,864.46, and court costs in the amount of $149.70.
Defendant did not file a response either. There is no genuine issue as to any material fact. Plaintiff has granted motion for summary disposition pursuant to MCR 2.116C9 and 10. Judgments granted in the amount of $3,014.16, consisting of the principal amount of $2,864.46, court costs of $149.70, total $3,014.16. You can submit your judgment.
That followed shortly. Thank you, Your Honor.
Thank you. All right, so I'm moving on from that one. Now I have Paul Ollie versus Bank of America. 2602933. Do they have somebody here?
The Bank of America representative is on Zoom, Your Honor. He is out of state.
Good morning, Your Honor.
Go ahead, your name?
I'm not counsel. I'm a representative of the bank. My name is Dwayne Dumler. I can spell it if you like.
I can see your name. I'm questioning, this is a small claims case. Lawyers can't proceed in small claims. If you want to have the case removed, your name, sir?
Paul Ollie.
If you want to have the case removed to the General Civil Division, you'll have to file a notice, a demand for removal.
I'm not an attorney, Your Honor. I'm an assistant vice president of the bank.
I'm sorry. I thought you said you were an attorney. My apologies.
No, you're good. Thank you, Your Honor.
And are you, why would you, okay. Do you guys want to sit in a room and talk about this? Counsel? I mean, Mr. Dumler?
No, Your Honor. I do not believe we have negotiations to. I don't believe we'll be able to settle this.
How long has your mom been deceased, sir?
She's still alive. She's 81. No one said she was deceased.
I know, I'm sorry. I read into that. My apologies to you. Glad she's not. Do you have the physical CD?
I do.
Have you looked into this, Mr. Dumler? I mean, I can't imagine under any scenario, and I haven't sworn anybody in yet. I'm just trying to figure this out. If they purchased a CD with Bank of America and there were other mergers, the bank would have had to assume any liabilities, which would include a CD, right?
Yes, I've looked into it, Your Honor, and we do not have record of it coming from another bank.
Let me see that.
This?
Yeah. Did you send that to Mr. Dumler?
Yes.
That's got to be worth some money now. Almost was the interest paid every year? Was interest on the CD paid every year? Is that the question?
Do you mean, did I collect anything or?
You or your mother?
No, it's never been tried to be redeemed at all. We've never made any withdrawals.
Hey, this says, you said here, my mother purchased a CD on November 2180 with Heritage Bank.
If you flip open, there's two different versions in there. That's the original one from Heritage and then the follow.
This courtroom sentencing brings a long-running and deeply personal conflict to a critical moment as Victoria Mott appears before the judge after pleading guilty to 3 counts of violating a harassment injunction. But as the hearing unfolds, it becomes clear that the court is not looking at these 3 violations in isolation. The victims describe a much larger pattern of conflict that, according to their testimony, had been going on for years. Christy and Jason Haskins tell the court about the fear, frustration, and disruption they say they have experienced. They describe unwanted appearances near their property, concerns about their safety, and the steps they felt forced to take in order to protect themselves. Security cameras were installed, and what should have been a peaceful home became a place where they say they were constantly watching and waiting for the next incident. For the victims, this hearing was not simply about punishment for 3 charges. They wanted the judge to understand the emotional toll that the situation had taken on their lives. Jason Haskins gives his own account of the situation and explains why he believes previous warnings were not enough. He describes incidents that he says made him feel unsafe on his own property and argues that stronger consequences are necessary to finally bring the conflict to an end. The prosecution supports that argument and asks the judge to look at the overall history of the case. While Victoria does not have a significant criminal record, the state argues that the repeated nature of the alleged conduct is what makes the situation so serious. The prosecutor also discusses personal struggles that may have played a role in Victoria's behavior, including possible trauma, substance issues, and mental health concerns.